Welcome back. We turn our attention now to the retrial for a Wisconsin man accused of killing his wife with antifreeze. And with that, criminal defense attorneys Brian Silber and Casey Early back with me to dissect what we just saw. What was your reaction to the judge's ruling on this, Brian?
So it's not uncommon. I understand where the defense is coming from. When they call someone a victim in a homicide trial, it presumes they've been victimized. If they're using self-defense as a defense, if the defense is claiming that while there was a killing, it wasn't a homicide, the word victim may not be appropriate. So I understand where they're coming from, but I also understand where the judge is coming from. It's not exactly the most prejudicial thing that's going to be presented in this trial. They're going to have 125 expected witnesses. This is going to go on for 6 weeks. At the same time, he's expecting the prosecution to conduct themselves appropriately and not be using the word victim, 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 victim every 4 seconds, but just to use it in natural discussion. So it sounds like he took a balanced approach, but I definitely understand where the defense is coming from. Some defenses, you're not challenging the fact that there was a homicide. You might be challenging who did it. In other cases, you might be challenging the fact that it is a homicide. Yes, there was a, but maybe the alleged victim was the aggressor. And by the way, look what I just said. I used the phrase alleged victim. That may have been something that the defense should have countered for and said, Judge, we understand where you're coming from, but at least have the prosecution use the term alleged. And that may have been another way to balance it.
Well, Brian, what are your general thoughts about voices beyond the grave? How much skepticism is there?
Well, it depends on the context and what was said. I did read that the law has changed, actually, since this appeal came down, and it is now admissible. I don't practice in the state of Wisconsin. I'm certainly not admitted there in their state court, at least. So I'm not familiar with the rule that they're alleging. Normally, this would be hearsay. But for the defense, it really ties one hand behind their back. The whole reason why hearsay is inadmissible is because the person who makes the statement or writes the letter or makes the allegation is not there in court to be questioned. And that's how we get to the truth in courtrooms, is we ask questions. If you recall, there's a direct examination by the prosecutor. So-and-so, tell us what happened, what was done to you. And then the defense gets a chance. They get to ask questions too. So in this situation, when you're admitting a letter, it's a one-sided thing. The prosecution gets all the benefit, and the defense gets no opportunity to challenge it. It's taken at face value, but of course they'll have the opportunity to argue that.